Welcome everyone to lecture number 41. Okay, in this lecture we are going to start the doctrine of basic features topic. So, what exactly this doctrine of feature topics mean? So, what happened? There were multiple amendments that were going within the constitution, and there were fights that was being raised whether the fundamental right is amendable or not. Okay, so in that perspective, this term was coined that even the fundamental rights are amendable. Okay, but when you are proceeding for the amendment of the fundamental rights, so at nowhere, at no scenario, you are going to change the essence of the constitution. Essence means that the basic structure of the constitution. What exactly this basic structure? Basic structure is completely a subjective term that courts will be interpreting it as per their understanding. Okay, so what the basic understanding means, what whenever the constitution was enacted, it was for the betterment of the India. Okay, betterment of the citizens of the India. So if let us suppose one amendment that has been done by the by the parliament is going to snatch some of the powers from the Indian citizens, or completely snatching any rights from them, so in that case Supreme Court can strike it down and will say that the particular amendment is completely against the fundamental rights, or completely against the basic structure of the constitution, so that amendment is completely illegal. Okay, that kind of perspective was introduced through this doctrine of basic features. So the Supreme Court of the India, the Supreme Court of India enunciated the doctrine of basic structure, of the constitution, in which case? In Kesavananda Bharti case. In Kesavananda Bharti case. Okay, so this was firstly enunciated by the Supreme Court, in which case it was enunciated in the case of in the Kesavananda Bharti case. Okay, now the Supreme Court held in the Kesavananda Bharti case, there are certain basic features of the Constitution of India which cannot be altered by an amendment of Article 368. So what the Supreme Court said? Supreme Court said that in this Kesavananda Bharti case, that there are certain basic features of the Constitution of India. There are certain basic features of the Constitution of India which cannot be altered by an amendment under Article 368. And we know that in the Article 368 what kind of majority is required? A special majority, and if it deals with the federal feature of the country, then it has to be ratified by the 50% of the state through the simple majority by the states, and by the parliament it will be the special majority. Okay, understood? So we have discussed all those things. So Article 31C introduced by the 25th Amendment Act, that if any law, what happened in this case we'll see. So Article 31C introduced in the 25th Constitutional Amendment Act provided that if any law seeks to implement the directive principle contained under the Article 39 B and C, that is regarding socialist control and distribution of the material resources of the country, such law shall not be void on the ground of contravention of Article 14 or Article 19. The Supreme Court later held that Article 368 did not empower the Parliament to take away judicial review in the naming of amending the Constitution. So what happened, that the amendment of the Constitution, that even if whatever the if the state is trying to implement the directive principle present under this Article 39B and 39C, and if it is violating Article 14 and Article 19 also, then it is if it is violating Article 14 and Article 19 also, it will be not lawful. It will be considered as a law, and it will not have a judicial review also. Okay, Supreme Court said that okay, whatever you have said, we are fine with that, it will not counter that Article 14, Article 19 and all. But if you the point you are telling, that the judicial review is not will not be allowed, it is completely against the basic structure of the Constitution. No judicial review is possible, that Supreme Court said. Okay, and the 42nd Amendment 1976 inserted two clauses in Article 368 to the effect that Constitution Amendment Act shall be called in question in any court on any ground. These clauses were nullified by the Supreme Court in the Minerva Mill case. What is the Minerva Mill case? We will see in detail. Okay. So there are three implications of the decision in the Kesavananda Bharti case. What was the three implications? Currently we are basically reading the Kesavananda Bharti case. Okay, so there are three implications of the decision in the Kesavananda Bharti case. Okay, what was the first one? That any part of the Constitution may be amended as per the procedure laid down in Article 368. Okay, second point, no referendum or reference to Constituent Assembly is required. So see what happened in the Golaknath case, like there was a point made that Constituent Assembly is required for a certain kind of amendment. So that regarding that, the court reverted back his decision and said that the no referendum or reference to Constituent Assembly is required to amend any provision of the Constitution. Okay, and the third point, which is very important, basic features of the Constitution cannot be amended. Okay, so these were the three important implications that were derived from the Kesavananda Bharti case. Okay, so now the question arises, what is this basic feature? Whenever we are telling that basic feature, it is a completely subjective term. It is completely subjective term. It has an endless meaning. Okay, it will get changed over a period also. Okay, so currently if you see as per we are evolving now, the term like the AI, artificial intelligence, and all digital era, all our things are including currently under it, and these all things are becoming a part of our life. So those things will also be considered as the basic features currently. Okay, so now we have to understand what exactly is the basic features. So there is no limited list of basic features. In so many decisions, in the Supreme Court has declared different things a basic feature. Prominent among them are the following. That what are the things that has been listed by the Constitution as their basic features. Like few of the prominent things that are laid by the Supreme Court as the basic features. It is endless. Let me. It is endless. Okay. Prominent topic that will be considered as the basic features will be first, supremacy of the Constitution. Constitution is supreme. Okay, that is one basic feature. Second, rule of law. Everything will be applicable as per the law. The principle of separation of power. The principle of separation of power, that judicial, executive, and legislative all are independent to work. Okay, and that's where this term judicial review is also considered under the basic features. Judicial review, Article 32. Okay, the objectives specified in the preamble in the Constitution. The objectives, what the objectives that were specified within the preamble, we have studied all those things. All those objectives will also be considered as the basic features of the Constitution. The objectives specified in the preamble. Okay, now federalism will be the basic features regarding the states and all. Secularism, sovereign democracy, these all are the objectives that we have discussed in the preamble. All those things will be included under it. Okay, this is a kind of a state that will have sovereign, democratic, republic structure. Freedom and dignity of the individual. Freedom and right to life, that will be considered under it. Freedom and but right to life is not now under the uh, uh, there are certain like what I will tell amendments and consideration that part will be considered the right to life as a fundamental right, or no, that will be considered as a constitutional right. Okay, so there are certain questions that have been raised in the past, we have discussed in the old sessions. In the coming sessions also we are going to discuss all those things. Okay, freedom and dignity of the individual. Unity and integrity of the nation. Principle of equality. Principle of equality, not every feature of equality, like not we are considering literal meaning of equality. We have studied right to equality and all. Okay, in that we have discussed in detail. Okay, so not every feature of equality, but the essence, quintessence of equal justice. Okay, we know that we have discussed, like, whenever we are telling the right to equality doesn't mean that in literal meaning that we have to give like kind of reservation and all that we used to provide for the lower strata of the society. Okay, that kind of right to equality we are talking about. Okay, that give to equal opportunity to everyone. Okay, the essence of, you can't amend the fundamental right by violating the essence of the fundamental right. Okay, fundamental rights part 3 is amendable, but you can't amend the essence of fundamental right. Understood or not? The essence of fundamental right in part 3. The concept of social and economical justice to build a welfare state, that is also a part of basic structure. The concept of social and economical justice to build a welfare state. Okay, the balance, the fine balance, the balance between fundamental right and DPSP, directive principle of state policies. Okay, parliamentary system of government, that is also a basic structure. Parliamentary system of government. Limitations upon the amending conferred by the article 368, that is also basic structure. Limitation upon the amending power conferred by article 368. Very important, judiciary independence. Okay, that will also be a part of a basic structure of the constitution. Basic features, doctrine of basic features. Okay, principle of free and fair election. Principle of free and fair election. And effective case of justice. And powers of Supreme Court under Article 32, 136, 141 and 142. We will discuss all those things in detail when we are going to discuss for the Supreme Court and all. Okay, so these were included under the basic structure of basic features of the constitution. Okay, so we have understood like what exactly is basic. This is completely endless, it is not going to end, it will get added over a period. Okay, and this was term this term was given recognition through the Kesavananda Bharti case. Okay, now I just want to give you a few historians and all that they have quoted about the Indian constitutional structure, that in a very positive way. That one is our Granville Austin. Granville Austin is a American historian of Indian constitution. Okay, he used to read about the Indian constitution and all of that, how they have developed and from where they have picked up and all those things. Okay, so he has stated one term that the amending process in fact has proved itself as one of the most ably conceived aspects of the constitution. What does it mean? I just tell you in literal meaning that amending process of the Constitution of India is unique in the world. As per Granville Austin, he said that amending process of the Indian Constitution is completely unique in the world. Okay. See, there was one another writer, three in one book also Indian Constitution has been appreciated. Which book? Endurance of National Constitution. He was written by the Jacques Elkins, Tom Ginsburg, and James Melton. Okay, they used to examine the cause of constitutional endurance from an institutional perspective. What they have said, what they have written in this book, in the book name, the Endurance of National Constitution. In this book, they have written that India's amendment provision strikes the optimal balance between the flexibility and commitment. Okay, so you can use these kind of terms within the answers that will enhance the beauty of your answer. Okay, so this was all about in this lecture. We'll meet in the next session. Thank you.